Nairobi.
All right, we now want to take you live to Parliament, where the sessions are underway, and we'll be keenly just listening briefly on what's transpiring at this hour.
It is an issue that the Committee on Education ought to have considered. Lastly, on the constitutionality of the bill in respect to Article 43(1), paragraph F of the Constitution, I will restrain myself from guiding this House on the matter, as I know that it relates to a question of violation of the right to education as an economic and social right contained in the Bill of Rights. As I have guided this House severally, a question on the violation of a right and fundamental freedoms falls within the exclusive jurisdiction of the High Court in terms of Article 165 of the Constitution. I do not intend to depart from my previous rulings on this matter. I resume my seat to allow the others to come in. The member for Karachuonyo, you are in and out. You are confusing people. And no, given your height, nobody knows whether to trend on you or to you. Member for Shinyalu, you are walking in. I just resumed my seat to allow you to come in. This member for Nairobi doesn't want to sit. You see the members who are coming late. I may just wish to remind you that those of you, and I believe maybe you may not have known, but I'm sure those of you like the Honorable Jimmy Angwenyi would recall the old days in the villages, this being the last day, when people would close schools. They chose the people with whom to close. So I hope the member for Nairobi is not choosing the Honorable Wangwe to close with. Honourable members, moving on to the second issue, which is with regard to the issue of whether the bill concerns county governments, I do note that despite this issue falling squarely under the province of the two speakers of Parliament, in line with the provisions of Article 110(3) of the Constitution, an argument may still be sustained in the event amendments proposed to the bill affect its nature. A perusal of the bill reveals that Clause 9 of the bill as published seeks to repeal and replace Section 26 of the Universities Act to require the Commission on University Education to ensure accessibility of public universities by all counties. Additionally, the amendments proposed to the bill by various members, including those proposing partnerships between universities and counties, and the Committee of Public Land held in trust for the public by counties, may result in a designation of the bill as a bill concerning county governments in terms of Article 110, Clause 1 of the Constitution, as read together with Part 2 of the 4th Schedule to the Constitution, if passed by this House. And this now settles the second issue. Honourable members, on the third issue, I will not belabor myself on the question of the adequacy of public participation on the bill. I've ruled on numerous occasions in this Parliament on the need for the procedures of the House to incorporate meaningful public participation as directed severally by the courts. I've also on numerous occasions emphasized on the need for this House and its committees to ensure that public participation is not a cosmetic process, but one of probative value. In this regard, I note that the report of the Departmental Committee on Education on the bill seem not to meet the threshold set by this House on meaningful involvement of the public. At face value, I'm at pains to discern from the two reports tabled by the committee any meaningful engagement with the key stakeholders affected by the bill. In the reports, there are no indication as to whether the committee, at the very least, invited the vice chancellors of all the 52 chartered universities, including 32 of which are public, and the 12 universities with letters of interim authority to make representations on the bill. There is no mention of whether the committee invited and considered the crucial input of stakeholders such as the Commission on University Education and the existing Universities Fund Board, and whether it considered their views. If it did, there is no record of it in their report to the House and the addendum to the report. To my mind, a meaningful public participation exercise should mirror the current practice adopted by the Departmental Committee on Finance and Planning, which invites its principal stakeholders to make submissions on any business appearing before them, even if they do not send any memoranda. This allows them a broad perspective over the issues under their consideration, whether or not such stakeholders opt to submit memoranda in response to a call for public participation. The paucity of the committee report becomes more glaring when one takes into account the allegations made on the floor of the House that the response to the committee's invitation for public participation drew rather partisan submissions, including submissions from a forum sent to represent the vice chancellors of universities instead of the actual vice chancellors themselves. I'm of the opinion that the exercise conducted by the committee would have been sufficient if it involved its key stakeholders and persons directly affected by the bill by default. Honourable members, finally, on the fourth and last issue, which is whether the harmonization of amendments proposed to the bill was properly executed, I do note that Standing Order 131 is a device that assists committees to harmonize amendments, in effect assisting the House and members to avoid unnecessary objections during the committee or the whole House stage. I however note that a number of members who joined issue with the Honourable Ichongwa noted that they proposed amendments to the bill, but their efforts to have their issues addressed during the harmonization process envisaged that the Standing Order 131 was less than fruitful. From the foregoing, this indicates that the harmonization or the winnowing process under Standing Order 131 by the Committee on Education and Research did not meet the dictates of the same standing order. Honourable members, whereas I note that lack of the harmonization process does not in any way impede a member from proceeding with the amendments in the House, and indeed, as ably noted by the Honourable Dr. Wilberforce Ojiambo Udo, the amendments proposed by the members were included in the order paper for the afternoon sitting of the House yesterday, and also included in the order paper for this particular sitting. A committee directed to conduct the harmonization process under Standing Order 131 must demonstrate compliance with the standing order. It, however, appears from the submissions made by the members in yesterday's afternoon sitting and the plethora of amendments contained in the order paper that the winnowing process failed to meet the bare minimum of the expectations of Standing Order 131. In light of the foregoing, what then is the prudent action to be taken at this stage of the bill in view of the concerns raised? I do note, honourable members, from the outset that in addition to the concerns raised by the various honourable members, the bill has attracted numerous amendments, as may be seen from the order paper. This, in my view, is a pointer to the need for a rethink of the bill by its proponents. Insisting on the prosecution of the bill in its current form, despite the objections, questions of constitutionality, concerns on the quality of public participation undertaken on the bill, and the numerous proposals for amendments, may only easily expose any resultant act passed by this House to easy challenges in courts of law. Conscious of the fact that the House is scheduled to adjourn sine die today, in view of the forthcoming general elections, I do note that if the committee had taken time to address some of these issues when they were first raised during second reading, we would be facing a different situation today. Honourable members, it is also notable that the issues raised by the honourable members touch on three main issues, main clauses, being clauses 13 and 14 on the powers of the Cabinet Secretary in respect to the public universities, and clause 18 of the bill with regard to the university's Fund Board. These clauses form the cracks of the flesh and the pith and substance of the bill. Indeed, One may want to argue that the easy way to cure questions of constitutionality is to sphere or expart the unconstitutional clauses in a bill. However, honourable members, should I order expurging of the 3 clauses from the bill, this will also require me to also order expurging other clauses and consequential amendments to the spherance of the 3 clauses. From a perusal of the bill, if you are to expurge clause 18 of the bill, you may also need to expurge clauses 16, 17, 19, and 20, among other related clauses. This will leave a shell of a bill with no clause to deliberate on. Suffice to say, the sufferance of clause 18 of the bill would also be an abdication of the watchdog and oversight role of this House of ensuring accountability on the utilization of public funds. In light of the foregoing, I am therefore of the considered opinion that it is prudent and advisable for the bill to be republished in order to align it with the Constitution and take into account the concerns raised by members on the issues of constitutionality, public audit, public participation, and the nature and extent of the discrimination in the policy that seeks to commit a student eligible to attend a cheaper public university to a private university with a higher fee requirement. Honourable members, as your Speaker, I have previously ruled that I cannot close my eyes even when faced with competing unpleasant scenarios. In the present case, the question as to whether I should let the House to commit a constitutional requirement to a vote or stand down a bill that has attracted serious questions by members of the House, I would prefer standing the bill down to allow its regularization. Any other decision would, in my view, be reckless and would establish a defective precedent. In light of the foregoing, the bill cannot, in its present state and form, proceed for consideration in the committee of the whole House. Honourable members, I thank you for raising the matter and for all your contributions on the ensuing debate of valuable insights that undoubtedly shall enrich future interrogation of bills before the House. In summary, this is my finding. 1. That in the interim and pending further interrogation of the constitutionality of the Universities Amendment Bill 2021, the bill fails to fully actualize the provisions of Articles 201 and 229, Clause 5 of the Constitution on the need for reporting and audit of the utilization of public funds allocated to private universities. 2. That the Departmental Committee on Education and Research failed to propose any remedy for action by the House to actualize these 2 provisions. The only proposal close to actualizing one of these provisions is by the member for Seme constituency and the member for Kikuyu constituency. However, at this stage, leaving the inclusion of a provision seeking to reflect a constitutional principle to the vagaries of a vote of the House would be imprudent. 3. That to the extent that the bill makes provisions touching on county governments and that various amendments, if passed, would require an interaction between universities and the functions reserved for county governments, the bill is likely to concern county governments within the meaning of Article 110, Clause 1 of the Constitution. 4. That the public participation exercise conducted by the Departmental Committee on Education and Research was not sufficient as it did not involve its primary stakeholders and persons directly affected by the proposed legislation by default. The committee ought to have invited, heard, and considered the views of the Vice Chancellors of at least a reasonable fraction of all the 52 public and private chartered universities, the 12 institutions with letters of interim authority, the Commission on University Education, and the Universities Fund Board at the very least. 5. That based on the submissions by the members in the House and the plethora of amendments contained in the order paper for yesterday and today's afternoon, the harmonization of the amendments proposed to the bill by the committee did not meet the dictates of Standing Order 131. 6. And last, that the Universities Amendment Bill 2021 be and is hereby ordered to be republished in order to take into account the concerns raised by the members and align it with the expectations of Articles 10, 43, Clause 1, Paragraph F, 201, and 229 clause 5 of the Constitution. The House is accordingly guided, and I thank you, honourable members.
All right, National Assembly Speaker there, Justin Muturi, is overseeing a session in Parliament as parliamentarians of the 12th Parliament prepared to go on recess ahead of the August 9th elections. We'll be keeping an eye on some of the key outcomes from today's session and what will be some of the bills that the next Parliament will have to complete before they are due legally. We have much more coming up on the other side of the break. Keep it locked here on KTN News.